Welcome to today's presentation, HIPAA compliant texting and emailing, strategies for avoiding liability. My name is Rachel Rose and I'm an attorney in Houston, Texas. I have served as both a consultative and a testifying expert, and I'm extensively published and a frequent presenter across a wide variety of publications and organizations. So today I'm going to begin with what I term HIPAA happenings, and also then delving into 21st Century Cures Act considerations, texting, emailing, and HIPAA, the 2024 HHS updates. Compliance programs, whether new or evolving, are a critical factor in risk mitigation. And I will end with a conclusion. But before we begin, I really want to focus on key distinctions as it relates to emailing and texting. Well, a medical record means any item, collection, or grouping of a conglomerate of information that includes protected health information is maintained, collected, used, or disseminated by or for a covered entity. That we look at in terms of what providers' obligations are, not only providers, but covered entities in general and business associates, versus an individual's right to request their medical records, and became effective in 2005, only relates to electronic protected health information. So those are just considerations up front. Utilizing these recognized security practices, including, as you see, Section 405D of the Cybersecurity Act of 2015, NIST standards are required to be met by every federal government agency. So here's an example of a state action where the California AG settled with a well-known laboratory. I want to highlight some items related to enforcement actions. I mentioned the Colorado bill, and this is really important. And if you think about texting and emailing information, what type of information are you emailing, or what AI application are you using? As mentioned, this law was signed by the governor on April 17th of 2024. So at the outset, I mentioned two prongs: patient requests, and patients do have the right under HIPAA to access their health information under 45 CFR section 164.524. Also, a couple of items to consider regarding an individual's right. I would recommend going to 164.524. So all of this is laying the foundation to get to what HHS published in February of 2024 related to texting and emailing. But first, this is critical because the final rule that I mentioned of the 21st Century Cures Act basically has the conditions and maintenance of certification requirements for health information technology developers under the ONC Health IT certification program. Section 404 is the key area to look at regarding information blocking, as it is a practice by a health IT developer. So Section 4004, practices that restrict authorized access, exchange, or use under applicable state or federal law of such information. Information blocking exceptions. This is critical, as I mentioned before. So HHS has issued proposed changes to the HIPAA privacy rule. From my perspective, I would really look at these areas: reinforcing an information blocking attestation. This is critical. So statement 2 of the attestation. So ONC released a report to Congress, including information blocking by the numbers. Now, ONC's proposed rule on October 30th, 2023, I also wanted to highlight that the Cures Act also granted the OIG the authority to impose civil monetary penalties against certified health IT developers, charging patients for medical record copies, and an important notice regarding individuals' rights of access. So a portion of this rule was actually challenged in the federal court in DC that I mentioned, and here the case is the SIOX case, and this is actually found on the HHS website, so I would recommend going there, and it breaks down the payment items. This is key as this presentation relates to state laws as well. So CMS and texting, here is the memorandum, and basically it focuses on texting of patient information and orders for hospitals and critical access hospitals. Additionally, 42 CFR 482.24 and 485.638 respectively require that inpatient and outpatient medical records be accurately written. Also, CMS expects providers choosing to incorporate texting of patient information and orders into its EHR. Also, federal communication data breach reporting requirements final rule. This just became effective on March 13th of 2024. So no presentation is complete these days without hitting on artificial intelligence. This was issued by the White House Office of Science and Technology and feedback. NIST, this is their framework. They have an additional one called Cybersecurity Framework, CSF. Here is what I wanted to mention regarding the intersection of HIPAA and AI. We already know that AI has to be secure and that it cannot discriminate and it needs to protect privacy. You want to conduct that annual risk analysis, ensure PMPs are comprehensive and reviewed, require workforce training. Healthcare programs in general require 7 things. Here's the NIST 853 and a link to it, and controls are broken down into low, moderate, and high. So in conclusion, texting and emailing can be done in a HIPAA compliant manner, and it should be. It is incumbent upon a person in an organization to make sure that it is, continually ensuring that technical, administrative, and physical safeguards. So with that, I want to thank you for your time and attention here today. And I look forward to having you join me again in the future. So thank you.